Hello, everyone, and welcome to Thursday Talks with Chock. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chock Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Ashima Chock from our Houston, Texas office. Hi there, Ashima, and welcome.
Hi, thank you for having me here.
Thank you so much for being here. For today's topic, we will be discussing common pitfalls in employment discrimination. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions, please comment them below or email us anytime at info@chock.com. So let's get right into it, Ashima. Can you tell us, how does discrimination in promotion impact workplace morale?
So I think that's a very heavy duty question. You have to break that into parts and start with what is actually discrimination. So we have, the Labor Day just went. So, right, the Labor Day was all about protecting labor workers and employees, right? So it's the same way. There are a bunch of federal rules and regulations for protecting labor. So there's a protected class and there is protective classification as to the acts. So if you have some kind of bias or practices which discriminates that protected class or protected characteristics, that's what is discrimination. So then, you have to go back to see what is a protected class, what is protected to begin with. Now, there are different, there's Fair Standard Labels Act, there's FMLA, and then there is a bunch of employment rules and regulations which prohibit different people. So, but if you club all of them together, if there is a bias or if there is bias due to sex, age, gender, national origin, your citizenship status. There's a whole list over there for the protected class. And it's not just citizenship, it's also refugees, asylees, LPR status. And if you have any bias related to that protected class, that's discrimination. So that was the protected class, right? So if you have any rules and regulation, or if you act in a way which harms that particular class, then that's discrimination. So going back to your question, sorry, you'll have to read your question again.
So how does discrimination in promotion impact workplace morale?
So promotion, promotion can be multiple as well. Sorry, I keep breaking your questions. So
No, that's okay.
you have promotion, and then you're asking workplace morale. If you're not promoted, then obviously you're going to be dissatisfied with your work and you're not going to feel like putting your 100%. The layoffs, turnovers, and all will be high. Apart from just morale, you have to look at the other aspect. There's more than morale. You're looking for significant lawsuits against you as a company and against you possibly as a manager if you are the one managing and a supervisor. So it can happen both ways. Not sure if I answered your question.
Absolutely. No, that's definitely helpful. Thank you. Can you talk about what role company culture plays in preventing employment discrimination?
So, earlier we discussed what was employment discrimination. So if you have something, some act, conduct, or characteristics, right, which violates that protected class, that's discrimination. So if you have a culture which includes everyone, which promotes non-discrimination, which has clear-cut policies as to what to do, which does not have an attitude of let it go, it's not my fault. If you see something, you don't do anything about it, all those would impact. And the culture of the company goes a long way. If you have all policies in place, if you encourage inclusion, diversity, then that definitely helps you. And I can give you an example.
Great.
So, sorry, reiterate your question again.
How company culture plays a role in preventing employment discrimination. So what role does company culture play in preventing discrimination?
So if you have the culture where, you are, you have Arabs, you have Asians, you have Hindus, you have Jains, you have people of different culture. So sometimes you can pass funny remarks thinking you're trying to be funny without knowing that it can be very offensive to that particular person. So I think making people aware, giving them training as to how others may be impacted by your ignorance, so it's not necessary that you always have to have a bad intent. Even if the impact of your actions is wrong, it's still discriminatory, no matter what. Um, so I think if you have that clear, then that helps you out.
Absolutely, it does seem like a great idea to embed in the company culture inclusivity and, teaching people to be respectful of others and just be mindful of what you say. I mean, sometimes, like you said, the intention isn't bad, but the ignorance is, what ends up affecting the individual.
And there have been cases, where it can, if you have clear-cut policies as to what to do. So say, for instance, if you have FMLA allows you to have leave, right? So there was a case where the person was taking leave, was not, she was fired when she was not putting her time for lunch breaks and stuff like that. And she claimed that, okay, again, I'm entitled to FMLA leave and stuff like that. But there was a clear-cut policy and culture that you have to inform beforehand. And because of that, that lawsuit was thrown out.
Wow.
So in a similar case, there was another case where I think the lady had came back after a cancer surgery, and then she was having hard time working. So there are laws like, which requires you to accommodate if there is a disability or anything like that. So even though in this particular case, she was complaining that she was having a hard time working the regular hours, or, the fact that she did not make it explicit, but the person, the supervisor, could see that she required accommodation, but he still failed to do it. Even that was held to be discriminatory. So if there was a culture where people were more respectful and pay attention, then um, I think that definitely helps. And there was another case of Walmart. In that particular case, the Walmart actually hired third-party contractors doing supplying for janitorial workers and other stuff. So in this particular case, even though they were not exactly employees, because most of the federal laws cover the employees, not the independent contractors, the the independent contractors were actually for the third party contractor, right? Uh, Walmart was just hiring those independent contractors, but still it was held that it was very, very visible that the people you had did not have employment status to work. They were unauthorized workers. So because you were hiring them, you were still liable, and they paid, I believe, 11 million, apart from the contractors paying an additional 4 million in fines. So I think the culture is super important in knowing when you see something, say it or do something about it. Don't just play ignorance.
Absolutely. Great points. So how can employers avoid discrimination during the recruitment process? We did talk about, unintentional discrimination sometimes. So what do they need to keep in mind? What would you advise for employers to just avoid, discrimination during recruiting?
So there are different, the Fair Labor Standards Act is one of the acts which says how much an employee should be paid and what the overtime and some other requirements, right? And they actually just had a change not too long ago in July where they increased the wages. So there are few thresholds, right? There's a wage threshold to comply with the wage and overtime requirements, and then there is a job duties requirement. So what Fair Labor Standards Act did is they increased the salary. So the salary increased by about 23% to 844 a week. So everybody who works here has to pretty much comply with Fair Labor Standards Act in terms of wages and overtime requirement, unless you're exempt. And there are a few other rules, but in case of exemption, the salaries for executive, administrative, and professional, typically we call them EAP, and highly skilled executives or highly compensative executives, that levels have increased. So the implication for that is whether you are classified as exempt or non-exempt has a determination or great impact on how you are, whether you are discriminated or not. Because if you're considered as non-exempt, you have to pay the salary and anything the person works over 40 hours overtime pay. So now coming back to your question, sorry, and you'll have to tell me the question again.
How employers can avoid discrimination during the recruitment process.
Okay, so for during the recruitment, so I was telling you about FLSA, right? The Fair Labor Standards Act, which talks about the salary, and you have to classify them as whether they're exempt or non-exempt. So it's very, very important for you to begin with to classify them right. You cannot have misclassifications. Fair Labor Standards Act does not it's not applicable to independent contractors. So you cannot just to avoid mislabel somebody as independent contractor because you're only looking for more lawsuits. Because this rule recently was in place, if you had people who were classified as wrong, you have to take actions to reclassify them appropriately. Then, these days, the use of AI has become very popular. We are using AI technology in monitoring employees' work time, in hiring. So there have been a lot of lawsuits. And in fact, there have been even cases now where they have said that it's not just, I think it was out of California, actually. The case was where the vendor supplied an AI software to this company, and the plaintiffs filed a lawsuit, and EEOC filed a lawsuit stating that it was discriminatory practices and they were not hired because of the AI software, because it has, it has discriminatory algorithms and information used in terms of determination as to who qualifies and who doesn't qualify. So this was an interesting case because an employer is using a third-party vendor, right? But the court observed that the third-party vendor was really an agent of the employer and can be directly responsible for discriminatory practices. So, going this far is really critical. So even if, you can be liable for doing discrimination just by having an AI software which somebody else developed on your behalf without you knowing that it was discriminatory. So that
Absolutely.
was, so you have to be very careful on how you use AI. Then there was another case out of Illinois where an AI was used for, biometrics and gathering other data. And it was again held as it was a discriminatory practice on how it was gathering. The way it was gathering was discriminatory. So, and then there was a case where AI was used for monitoring, like I told you earlier, FLSA requires to pay time for up to 40 hours worked and anything over 1.5 times the time spent, right? So this company was using an AI software to track the monitoring of the time spent. So apparently off the clock work, like somebody is on, Teams call, they say on phone or doing other stuff, was not being tracked by the AI software, but they were paying according to the time spent. So that was considered as a violation of FLSA. So when you're using AI tools for monetary hiring or other purposes, you need to be very, very conversant with the fact that even though you are not part of it, you can be responsible for it.
Absolutely. Wow, those are some really good things to keep in mind. I know you mentioned a few examples of when lawsuits have come about because of discrimination, but can you give us a few common examples that you've seen employers make that lead to discrimination lawsuits? So like maybe some of the most common mistakes you've seen employers make that unfortunately did end in a discrimination lawsuit for them, but are there any that you can think of off the top of your head?
You know, we talked about protected class, right? So I remember there was a case up north where a police officer was actually redeputed to a different region, but her pay wasn't impacted. And, the duties remained the same. But but the fact that she was redeputed, even if could be a good reason or anything else, right? It was held to be a discriminatory practice, even though the Supreme Court in that case held that you don't really have to have a concrete injury. That itself is discrimination because your job duties are impacted. So anytime your job duties are impacted or you create a hostile work environment, that is discriminatory per se.
Okay, good to know. So how can training programs help in reducing employment discrimination?
So I think training programs are a must. I mean, if you don't have it, you're going to have it being imposed by the finding authority, like in the case of Walmart. You know, I mentioned earlier they hired third-party contractors, right? So in that case, in fact, they wouldn't have, nobody would have known unless there was a hit and run accident and the people tried to complain and somebody complained to them about illegal workers over there and it got traced back to people working at Walmart as those workers who were there. So in that particular case, apart from paying the fine of 11 billion, the Walmart was required as part of the agreement to have policies in place for training their managers as to what the labor laws are and how to spot non-compliance.
Mm,
So
interesting.
you definitely have to see what those are. Like otherwise there could be unintentional discrimination. Say for instance, like I-9, right? I-9 is like is one of those forms which is required by everybody to fill, whether you're a citizen or a non-citizen, everybody has to complete that I-9. So sometimes, and there was this case again with a company, what they did is, I think it was Securitas, if I remembered it correct. They were asking for, so they were asking for more documents than required as to what all you can provide to verify your employment or your identity, and then asking them to keep re-verifying it, and they were fined for doing it, right? So somebody may have a good intent, they have I-9 and they want to ensure compliance and they're doing it, but being overzealous is equally wrong. So you don't want to do that. There's a list of documents and the person employee can choose whatever they want to provide. You don't have to you can't ask for specific and you can't keep asking for re-verification. So there have been a lot of lawsuits where, you know, there have been reverse lawsuits as well, where people say that you're hiring more people on H-1Bs than citizens, and that's discriminatory, you know, that's again a discrimination no matter what. And then, you know, people feel like because somebody's undocumented or illegally, first of all, you hire them knowing it is wrong. Then you hire them knowing they're illegal and you discriminate. That's even worse because you think you can get away with it. But labor laws are, you know, some of the federal law like FLSA and others equally apply to them. So they can still come back for the wages. Like in this Walmart case, even though they said, oh, you know, people were let go and stuff like that, they can still come back for whatever time they were not paid. So, so I think appropriate training definitely goes a long way in explaining all of that.
Absolutely. Can you talk about the risks of not having a clear anti-discrimination policy?
If you don't have a clear anti-discrimination policy, all you're looking for is a lawsuit and fines and probably criminal enforcement, right? So you may not have an intent, right? You can have an impact and you can still have discrimination if there is Civil Rights Act, and if you do under that, maybe intent is required for having extra damages, but then damages are without cap. So if you don't have an anti-discrimination policy, what happens? If you had a policy and you don't comply with it, you can still have some excuse in mitigation. You know, look, I had policy, I did everything, I trained people, and still I did discriminate, it wasn't my fault, right? So that's the place. So you have things in place as to if there's discrimination, who to report, you have posters in place. People can go to you anyway if they know that if supervisor is doing something wrong, there's a chain, you know, and then you follow the practice consistently. In fact, I recently had a case where the same thing happened, where they had everything and the lady complained that, you know, she was discriminated because of age. And we said, no, that wasn't a discrimination because of age, because we had policies in place. There was a supervisor and she said she couldn't reach the supervisor. And we said there was a policy in place where she could go to the next higher up. So everything was in place. So it was perfectly okay. And she was able to get her lawsuit dismissed, and my employer was saved from discrimination lawsuit.
Wow, good to know. So yes,
Um,
if you are watching this and curious about the law, the policies you have in place, and do reach out to us. We're happy to look over them for you and advise you.
Yeah. So, I would just go ahead and tell you one more example. That was an interesting case. Um, so in that particular case, the employer had different set of contracts for people who were citizens and non-immigrants, and different for citizens, right? So there were different set of contracts. And for some people, he was giving them sign if they wanted him to apply for a green card or permanent residence, only for them. And that lawsuit was quashed and dismissed, saying that this practice was discriminatory.
Hmm.
And I
Interesting.
understand that sometimes the non-immigrants have to pay a high fee, so they kind of sneak in the clauses for liquidated damages that, okay, we can't straight ask you for the fees and stuff, but if you leave, you'll have to pay this much in liquidated damages, but that is nothing but disguise penalty. And you're still going to be held liable for it. Or frequently I see that there are non-compete provisions, especially for non-immigrants, that you cannot go work with anybody else if you decide to sponsor you, and you cannot have those. I mean, the non-compete recent law was still put on hold, but still non-competes are heavily scrutinized, and you cannot have it per se.
Absolutely, that's really good to know. So, what are some examples of unintentional discrimination in the workplace that you've seen or heard of or, personally experienced?
So, we had this interesting case where an employee was laid off, right? He was an African American on race. And then, so this is one of the cases we handle. So, in this particular case, the person it just happened that others were laid off, and he was laid off, and he happened to be that. But the policies were clearly in place. We didn't intend to discriminate against him. There was absolutely no discrimination. Um, and in fact, all the others who were discriminated were younger. And so there was this claim filed for discrimination based on the age and race was what was filed, and the lawsuit was dismissed because it was unintentional. It just happened that it happened during that time, but it wasn't intended to be that way. So that's one of the cases. And then there was another, uh, there has been a case where I think it was an Abercrombie, if I'm not mistaken, where the lady interviewed for hijab, and the company policy required them not to have any hats on in public during when they're on the floor, but that she insisted on wearing hijab, and she said hijab wasn't a hat, and the supervisor said, we did have a policy saying no hat, we didn't discriminate you on hiring because you were hired, but it was held that that's they should have accommodated. So you have to know that you are required to give reasonable accommodation if you can. So that
Absolutely,
was
and,
held to
and
be a
that makes
discriminatory
sense.
practice.
So, how can employers address pay disparity without discriminating? This is kind of a tricky one.
So, we know there's a protected class. We know there are protected characteristics, right? You don't want to you want to do something, do based on merit. You pay them based on merit. You pay them based on seniority. There are a lot of other things. In fact, there is anything other than, any of those things, nothing, you don't, I know even in this day and age, men are paid more than women, but that discrimination per se. But you don't want to do that. You want to make sure that everybody is paid equally. If you have to do disparity in pay, then do it based on merit, seniority, and anything other than those protected characteristics. Now, we talked earlier about FLSA. So what that has done is it has increased the level of salary. So I think it's from 684 per week. It has gone to 844 for exempt from July of this year. And then it jumps again in January of 2025 to 1128 a week. And it doesn't matter whether you're full-time or part-time, you have to be able to pay this to be categorized as non-exempt. And for highly skilled, it's jumped 232,964 from 107,432. And from next year, it jumps to 151,164. So the question comes, what happens if two people were paid the same salary before for the same job work? But now, because of this, some of them have to be jumped up and some are being hired new. So that's when I was telling you earlier that we have to think about reclassifying or how we're going to go about this. I mean, you can only have 10% attributed to bonuses and commissions. Everything else, you have to figure it out, how you classify. So that could actually lead to more discrimination lawsuits if you don't reclassify or take care of it right now.
Wow, that's really good to know. Great points there. I know we are short on time, but I do want to ask you one more question. How would you recommend job descriptions be written to avoid discriminatory language?
I've been, you're probably bored by now, but I've been telling you about the protected class and protected character state, because that's the key. It doesn't matter. The laws are the same. You use AI, you don't use AI, you have to comply with the basic labor laws. The laws are still the same, If you're using AI technology and others, use it where it is non-discriminatory intent, right? You have job description, you don't want to, you want to be gender neutral. You don't want to ask about person's age, sex, or anything which is the protection, right? You don't want to ask any of that. Some people ask, they try to be smart and ask the date of graduation. When did you graduate? Yeah, you can always backtrack and figure it out, right? What the age is by that. For most part, you don't want to be doing that. You don't want to be saying citizens only. That's discrimination. You can't do that unless unless you're one of those federal government things which requires it to be a citizen. You can't post that. You can't say nobody with with this accent, or we only need this English speaking person unless that's a requirement, or in fact, we only talk English at work in the job description. So that's one of the requirements. You can't do that. I mean, job requires English. So the basic thing is you have to see what is the best practice for your place of work, what job you require, and what is needed to do the job, and leave everything else aside. I mean, what qualifications does a person must have to do the job, and not everything around it.
That makes sense. That's great advice. Yes. I mean, what are the requirements needed for the job, and that should be what the job description is based off of.
Yes.
Absolutely. Wonderful. Thank you so much, Ashima, for all of your insights and, all of the wonderful examples you provided. Absolutely so interesting and great to know. And it definitely really helps us remember, I think, these situations when it's an example of a company who went through this. So thank you so much for your time and sharing these insights with us and the great advice. That is all we have time for today. So this does bring us to the end of our conversation. Thank you everyone for joining us today. A special thank you to you, Ashima, for sharing your time and insights with us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or comments, email us anytime at info@chock.com. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again for joining us.